All right, on the phone is Senator Angela Burks Hill. Good morning, ma'am. How are you?
Good morning. How are you?
I'm okay. It seems like this is deja vu all over again, doesn't it?
It does. It absolutely does.
Let me give some people just kind of some background here of what we're talking about. Teresa April had a good article, and she was talking about of what happened in to the family and everything else. Well, Tuesday, it seemed like it just started all over again. Another day that members of the Cindy Williams family were awaiting another parole hearing for Mr. Williams III. It was supposed to be held on September the 16th. Here's a guy that was convicted and given 2 life sentences. James Williams III, happened in 2005, to a 2002 fatal shooting and partial dismemberment of Cindy Williams and his father, James Williams Jr., and he stays in prison 19 years, changing the legal landscape. The Supreme Court said if you were underage at the time of the conviction, then you are up for parole, et cetera, et cetera. Now, we had, I think, 27 House members who went and asked the parole board to reverse their decision, and apparently they decided not to do that. There was a lot of disagreement within some members of the parole board themselves, but apparently they had enough to get the guy out. So what happens when he gets out?
Well, he was arrested by the Pearl Police Department, from what I've read, for DUI. And then the parole board revoked his parole. And that was some months back. And like you said, the parole hearing was coming up again because he petitioned for parole again with his lawyer from the MacArthur Justice Institute up at Ole Miss. And the parole board was going to hear the case again, and the family was going to participate in the hearing. And then the attorney for the incarcerated petitioned the Hinds County Circuit Court for release on a technicality, just like how he wound up with parole without life, a technicality with the Supreme Court. And so here we are, because the George Soros-funded Hinds County District Attorney's Office and the lawyer from the MacArthur Justice Institute up at Ole Miss basically agreed that he needed to be out based on their interpretation of the statute, which I believe they're interpreting the probation statute, not the parole statute. But regardless of that, he's out.
There's two issues.
This was a court.
I understand. Angela, there are kind of 2 issues on this one. Number one, that it just happened again and he's out. And the key word that you said was months. This DUI thing happened just months ago, and he's back out again after that in a violation. I'm not sure that hasn't set a precedent in some cases as far as the recent paroles. But secondly is the manner in which they handle the family. And I thought didn't we, either the legislature or the parole board promised to make sure that notification was right. According to this article, Tuesday was another day by members of Cindy Williams' family. They were awaiting another parole hearing for Williams III that was supposed to be held September the 16th. I will remind you, today is September the 9th. This parole hearing was supposed to be September 16th, in spite of the fact that Cindy Williams was shot in cold blood by her stepson, who had then attempted to dismember them, et cetera, et cetera. But speak to that.
Well, basically, the Hinds County Court and District Attorney's Office, the judge in the District Attorney's Office basically steamrolled the parole board. And the parole board was no more aware of what was going on than Zeno Mangum and his family. We heard it through the grapevine. There was no formal notification until, like you said, last week, right before they were putting him out.
Yeah.
And so the victim didn't have a chance to say anything. Hinds County Court made their decision. Victims didn't have an opportunity to say anything to that court. Like they would have the parole board. The court made their decision, basically sends a letter to MDOC, I think, and says turn him out.
Was it the validation of the technicality? What was the technicality, or was the technicality so brazen that the court had no choice?
Well, you know, you got activist courts, and then you got courts that actually weigh the law.
Well, yeah, but which one was this, though? I mean, first of all, without knowing that.
Well, basically, what the court is saying is that a new misdemeanor crime is not a revocable offense. They're saying a new misdemeanor crime is a technical violation. So but they're looking at the probation statute is what they're looking at. And I think that unless or until we have an appellate court decision, if somebody, infinite wisdom in the state of Mississippi, you know, in MDOC or the executive branch would say, you know, we can't let this stand on Hinds County Court. We need to appeal this, or either we need to go back and we need to clarify the statute that probation and parole are two separate things, and that a misdemeanor new crime is not a technical offense when it comes to parole. So I think you have two options in the state of Mississippi, or you're going to continue to have lower courts do this.
So now you guys in the 2025 session is going to go back and change some codes in there to make that technicality, as far as DUI, not a technicality.
Well, not just DUI. It could be domestic violence. It could be assault. There's a lot of crimes that are misdemeanor crimes that you and I think are serious crimes. So I think we have to be very specific and say that it's the discretion of the parole board whether or not a new misdemeanor crime is a revocable offense, because it needs to be looked at based on the case-by-case basis and what the crime is. You know, I mean, domestic violence is a serious offense in my opinion, but under Mississippi law, first offense is a misdemeanor. DUI, first offense, is a misdemeanor under Mississippi law. But you and I both know that those things should be revocable offenses, and that the parole board should have the final say in who should be out and who should not be out, and we shouldn't have a Soros district attorney and an activist court overruling the state of Mississippi's parole board.
Regardless of all of that, and I agree with you, and we've got to clear this mess up and have something definitive for the families of the future of the victims. I mean, because we talked about this over and over in victims' rights, and this is not happening. So, but put all of that aside as far as the court's decision and the parole board. As far as the parole board's concerned, why wouldn't you notify? Because they knew he was getting out, regardless on which method, legal technicality, he got out. He's no longer in prison. He will be a free person out on the streets to walk around, and therefore, wouldn't it be easy to just notify the family of exactly what is going on?
Well, I spoke to at least one member of the parole board, and the parole board was not even aware of the Hinds County Court decision until I made the parole board aware of the Hinds County Court decision. So how could they notify the family when the court didn't give them any notice over a holiday weekend?
So the courts basically told the parole board, you have no function in this decision at all.
Basically,
not even to let them know what was going on.
Exactly.
Wow. Well, when you pay for a campaign, you know, and you got the source money, it sounds pretty good if this is what happened there. But I don't know.
Well, you know, the Hinds County District Attorney worked for the Southern Poverty Law Center for years and years and years, and then ran for district attorney. And, you know, it's widely out there. All you have to do is Google to look at the PAC that was set up and funded by George Soros to get the Hinds County District Attorney elected. It
amazes me, and I hate to go back to this, to Tasha Shelby. This poor lady sitting there, and nobody's paying attention to that. And I'm not sure how many other people deserve a parole above and beyond this guy, James Williams, Jr. But, man, I want to ask you when we get back, do you have any idea where he is, or will he be back in the same care that he was before he got in a vehicle and could have killed somebody, of course, driving while under the influence? More with Senator Angela Hill coming up in a moment or two from District 40. Back with more next. Back with Senator Hill I was looking at Judge Gibbs here. I don't see any donations that I can see here from George Soros. There could be, I'm not sure one way or the other. And it really has nothing to do with this particular case other than the Soros story itself. But do you know that for a fact or not?
The district attorney's office had to sign off on that, on the court order. It was an agreed order. So the assistant district attorney signed off on that order. So the Hinds County District Attorney's Office was the other party that basically represented the state and agreed that he should be turned out. And it's pretty common knowledge that the George Soros funded that DA campaign through a PAC that was called, I can find it here in just a minute. There was a PAC that was created.
While you're looking for that, I'll ask you also: do you know where Mr. Williams is as we speak? Is he back in the care of the same people he was before the DUI?
I would assume he's back in the area. The victim's family tells me that his mother still lives in the area, and that's who that he would be living with. It's called the Mississippi Justice and Public Safety PAC. It's a left-of-center PAC created in 2019 to fund the campaign of Jody Owens, a Democratic candidate for Hinds County District Attorney. It's a branch of the Safety and Justice Network, a project of left-wing billionaire George Soros.
So what's next as far as the legislature and as far as any bills like this? Because there was a lot of talk last year about just kind of revamping the entire parole board. And nothing. Well, I don't think anything came of that.
Well, I think two things need to happen.
Mm-hmm.
Both the parole and the probation statutes got muddied up under criminal justice reform. I don't think most Mississippians think that somebody ought to be able to be arrested for 3 misdemeanor new crimes, which could be domestic violence, assault, DUI, theft of $999. I don't think your average Mississippian thinks that somebody on probation or parole should get to commit 3 of those before they get revoked or brought back in. So the first thing I think we need to do is look at public safety and go back and straighten out those parole and probation statutes. Give the parole board clear authority to do what they need to do and revoke for a new crime. If the lower courts are going to continue to say that we can't revoke for a new misdemeanor crime, we have no choice but to go and clear up that statute. And the second thing is the parole board needs to be moved out from under MDOC and it needs to be put under DPS, under the Department of Public Safety. I think those are two things that the state of Mississippi deserves. The citizens of the state of Mississippi deserve a parole board that's going to get their records sent to them in a timely manner and get the correct information sent to them. And I think that we need to clear up the statute if it's that muddy so that we don't continue to have lower courts overrule the parole board and say that they can't do their job because of a technicality between what's a technical violation and what's a revocable offense.
Why would the parole board be having problems communicating with the Department of Corrections? And if those problems exist, they would still have the same problems with any other department out there.
Well, I think if you have someone working for the Department of Public Safety that is collecting those records for the parole board, we might have a better chance of them having all their documentation together before they sit down to review a case because, there's been instances in the past where I've had pieces of paper and documentation from the family that the parole board said they didn't have from MDOC. So that doesn't need to continue.
Angela, aren't the guidelines of what you should do and what you're supposed to do by the guidelines as far as letting the victims' families know and the timeline is set out, what they can do, how soon they can call when the parole boards. I think isn't all of that thing kind of set out?
That's already in statute. The victims are supposed to have at least 30 days notification or more. I can't remember if it's at least 30, but it might be more in the statute. And I think that, they were all notified. I think, you got Frederick Bell's parole that's coming up again in September from the Grenada convenience store shooting, and I know that those victims were notified, and we actually put more language in the statute to require the parole board to notify all the local police department from the area, district attorneys. So we even added some notification into the statute. Now, sometimes they were doing that for courtesy anyway, but we even put it in the statute, and I do know that all those entities were notified in that Frederick Bell case because I've heard from them.
Can you put in law, in statute, that the courts also must be party to this? They have to do the notification if this should arise again in the same circumstances as it did?
I think we could.
As always, it's a pleasure. Thank you, ma'am. I appreciate it. Yeah.
I don't know that the court didn't violate that already. There's a lot of victims' rights in statute, and I'm not so certain that the court didn't violate something already, but that's something we can go back and look at.
Thank you, Angela. Appreciate it, ma'am. Appreciate it very much. J.T. Mitchell joins us coming up at 8:35. Let's check out news from Fox and also SuperTalk News coming up next.